They just changed the rules. And most Americans have absolutely no idea. The Supreme Court of the United States just issued a ruling that dismantled the foundation of gun permit laws in dozens of states across this country. If you live in New York, California, New Jersey, Maryland, Massachusetts, or any state with strict carry restrictions, this ruling directly affects your rights. And if you don't understand what just happened, you could either lose your rights without knowing it or never realize you had them in the first place. Let me be very clear about what we're covering today. This is not political commentary. This is not opinion. This is a breakdown of a real landmark Supreme Court decision in plain English, so that you, as an ordinary American, understand exactly what it means, what changed, and what you are legally allowed to do right now. Stay with me through this entire video, because halfway through, I am going to walk you through the exact legal standard that now protects your right to carry, and most gun owners still don't know how to use it. Let's start at the beginning. For decades, many states operated under what's known as a may-issue permitting system. Under a may-issue system, a government official, a police chief, a local licensing board, sometimes a judge, had the power to decide whether you, a law-abiding citizen, had a good enough reason to carry a firearm outside your home. They called it proper cause or good cause, depending on the state. And in practice, that meant ordinary Americans, people with clean records, no criminal history, no red flags of any kind, were being denied the right to carry simply because a bureaucrat decided their reason wasn't good enough. You couldn't say, "I want to protect myself." That wasn't enough. You had to prove a specific, documented, elevated threat to your personal safety. Think about that for a moment. The government was requiring you to prove you were already in danger before they would allow you to exercise a constitutional right. That system just got struck down. In the case of New York State Rifle and Pistol Association versus Bruen, the Supreme Court ruled 6-3 that New York's proper cause requirement for obtaining an unrestricted concealed carry permit was unconstitutional. Justice Clarence Thomas wrote the majority opinion, and what he wrote wasn't just a narrow ruling about New York. It established an entirely new legal framework, a new test, for evaluating all gun regulations across the entire United States. This is the part that changes everything. Before Bruen, courts were using what's called a two-step balancing test to decide if gun laws were constitutional. Essentially, a court could look at a restriction, decide the government had an important enough reason for it, and uphold it, even if that restriction burdened your Second Amendment rights. That test is gone now. Justice Thomas wrote that the Second and 14th Amendments protect an individual's right to carry a handgun for self-defense outside the home. And then he laid down the new standard. From now on, for any firearm regulation to be constitutional, the government must demonstrate that the regulation is consistent with the historical tradition of firearm regulation in the United States at the time the Second Amendment and 14th Amendment were adopted. Read that again. The government now has to prove, using history, that a restriction on your gun rights existed, or something like it existed, at the founding of this nation. If they can't show that historical precedent, the restriction fails. Now here is what most people completely misunderstand about this ruling. A lot of commentators read this decision and stopped at New York's law was unconstitutional. They reported on it like it was a New York story. It is not a New York story. The Bruen decision created the legal standard that every federal court in this country is now required to apply when evaluating Second Amendment cases. That means gun laws in California, New Jersey, Maryland, Massachusetts, Hawaii, every state that operated under may-issue systems became immediately vulnerable the moment that opinion was published. And the Supreme Court didn't stop there. On the same day the Bruen decision came down, the court vacated and remanded several other Second Amendment cases from lower courts, ordering those courts to reconsider their earlier decisions using the new Bruen standard. They didn't just strike one law, They sent shockwaves through the entire legal system. Now let's talk about the practical reality on the ground, because this is where it gets complicated. Some states move fast. After Bruen came down, several states that had been operating under may issue systems were forced to shift to shall issue systems, meaning if you meet the objective legal requirements, the government must issue you a permit, period, full stop. They cannot deny you based on a bureaucrat's subjective judgment. But here is where you need to pay very close attention. Some states did not go quietly. Instead of simply complying with the ruling, several state legislatures passed new laws designed to do essentially the same thing the old laws did, just with different language. They added new layers of requirements, expanded the list of sensitive locations where carry was prohibited, sometimes so broadly that carrying anywhere in a major city became practically impossible, required character references, required in-person interviews, required lengthy training courses beyond what was previously mandated. New York specifically passed the Concealed Carry Improvement Act shortly after the Bruen decision, a law that many legal experts immediately criticized as a direct attempt to circumvent the ruling. And that fight is still being litigated right now. This is the tension you are living inside of today. The Supreme Court has told you, in the clearest language it has used in decades, that your right to bear arms outside your home is constitutionally protected. But between that ruling and your actual ability to exercise that right, there is a wall of state laws, local regulations, administrative delays, and politically motivated resistance. And if you don't know your rights, specifically and precisely, that wall wins. So let me give you the framework you need. The core principle from Bruen is this: the Second Amendment is not a second-class right. That phrase, second-class right, appears directly in the majority opinion written by Justice Thomas, and it echoes language from the earlier Heller decision written by Justice Antonin Scalia back in 2008. In District of Columbia v. Heller, the Supreme Court ruled 5-4 that the Second Amendment protects an individual's right to possess firearms for traditionally lawful purposes, including self-defense in the home, independent of any connection to a militia. That was the foundation. Then, in 2010, McDonald v. City of Chicago applied those same protections to the states through the 14th Amendment. Heller and McDonald established the right. Bruen told every state and every court exactly how to test whether a gun law respects that right. And the test is historical. It is textual. It is originalist. If a gun restriction doesn't have a firm historical basis rooted in the founding era of this nation, it does not survive constitutional scrutiny. Now here is the open question, and this is what every gun rights attorney in America is focused on right now. How far does the historical tradition standard actually reach? This is where things get genuinely complicated and genuinely important, because the historical record is not a simple document. Historians disagree. Courts disagree. When the government argues that a modern restriction is consistent with historical tradition, they often point to laws from the 1800s, sometimes even post-Civil War laws, to argue there is a tradition of regulation. The question courts are now wrestling with is, how close does a modern law have to be to historical examples to pass the Bruen test? Lower courts have been split on this. Some courts have applied Bruen aggressively, striking down restrictions on carrying firearms near schools, restrictions targeting people under felony indictment, and restrictions on carrying certain types of arms. Other courts have been more deferential to government arguments about historical analogs. And in 2023, the Supreme Court addressed this again in United States v. Rahimi, a case involving a man subject to a domestic violence restraining order who was charged with illegally possessing a firearm. The court ruled 8-1 that the federal law disarming individuals subject to domestic violence restraining orders was constitutional under the Bruen framework. But critically, Justice Thomas, the author of Bruen, was the lone dissent, and the majority's reasoning actually clarified something very important about how to apply the historical tradition test. The court said that Bruen does not require a precise historical twin for every modern law. It requires a historical analog, a law that is relevantly similar in justification and burden. That clarification will be litigated for years. So what does all of this mean for you specifically? Let me break it down by category. If you live in a shall-issue state, meaning the government must issue you a carry permit if you meet objective legal requirements, Bruen strengthened your position significantly. Any new restriction placed on your permit process is now immediately subject to the historical tradition test. If your state tries to add requirements that have no historical basis, those requirements are vulnerable. If you live in a state that was may issue and has now moved to shall issue under legal pressure, you need to understand that the transition may not be complete. State agencies sometimes move slowly. Bureaucratic resistance can delay compliance with constitutional mandates. Know the specific requirements in your state. Know the timeline. And if you are denied a permit without a constitutionally valid reason, you have the right to challenge that denial. If you live in a state that passed new post-Bruen laws designed to limit carry, like New York's Concealed Carry Improvement Act, you need to understand that the legal fight over those laws is ongoing. Courts have issued injunctions blocking parts of those laws. Other parts have been allowed to remain in effect temporarily while litigation continues. The legal landscape is moving, which means your obligations and your rights can shift. Here is the most important practical advice I can give you today. Do not assume. Verify. The Bruen decision does not mean every permit law is gone. It does not mean you can carry anywhere without a permit in all 50 states. What it means is that every restriction placed on your Second Amendment rights now faces a higher legal bar. And it means that laws which could not have survived that bar were and are constitutionally vulnerable. Before you carry, know your state's current law precisely. If you believe a law in your state violates the Bruen standard, consult a Second Amendment attorney. There are organizations, including the Second Amendment Foundation and the Firearms Policy Coalition, that are actively litigating these exact issues across the country. You do not have to fight alone. And if you are ever stopped by law enforcement while carrying, whether you have a permit or you are in a constitutional carry state, know this. You have the right to remain silent beyond basic identification in most states. You are not required to volunteer information about a firearm beyond what state law specifically mandates. Be respectful. Be calm. Do not reach for anything without verbal announcement. And if your rights are violated during that encounter, document everything, say nothing further, and contact a civil rights or Second Amendment attorney immediately. Let's step back and look at the full picture. The Supreme Court has now issued a series of rulings, Heller, McDonald, Bruen, that together form the most significant expansion of Second Amendment rights in the modern era of constitutional law. Each ruling built on the last. Each ruling made it clearer that the Second Amendment protects real, individual rights, not just a theoretical collective permission. And Bruen specifically put states on notice that subjective, discretionary permitting systems that give bureaucrats veto power over your constitutional rights will not survive legal challenge. That is a seismic shift. For decades, millions of law-abiding Americans in restrictive states were effectively denied the ability to exercise a right that the Constitution explicitly protects. What the court has now said, repeatedly, is that the Constitution means what it says, and the burden is on the government to justify any restriction on that right using history and text, not policy preference, not political convenience, not bureaucratic gatekeeping. Now I want to leave you with one final thought. because this is not just about guns. The Bruen framework, the requirement that government justify constitutional restrictions using historical tradition, is a methodology that could ripple far beyond the Second Amendment. Legal scholars across the ideological spectrum are watching how courts apply this test. Because the principle at its core is simple and profound. The government does not give you your rights. The government does not decide if your rights are convenient or manageable. The government must justify, using history, using text, using the actual founding principles of this republic, any law that restricts what the Constitution protects. That idea matters for every right you have, and understanding it, clearly, practically, without confusion, is the most powerful thing you can do as a citizen. If this video gave you clarity, if it helped you understand something that the mainstream news covered in 30 seconds and moved on from, hit the like button right now. Subscribe if you want to be notified the moment we cover the next major legal development affecting your constitutional rights. And drop a comment below. Tell me what state you're in. Tell me what questions you still have. I read every single one, and your questions shape the next video. This is your country. These are your rights. Know them.